do have a verdict reached in the James Crumbley trial.
Verdict has been reached in the Jennifer Crumbley trial.
Guilty of involuntary manslaughter as to Tate Neer.
We find the defendant guilty of involuntary manslaughter.
This really opens up a Pandora's box of potential liability for parents going forward, depending on how far prosecutors seek to do this. I guess I would ask the question, is this just? I understand, people are very upset about these school shootings and they feel helpless and they feel like no one's doing anything about it. Is this just? How far are we willing to take this? My name is Steve Baric. I'm a former gang prosecutor in Orange County, California. I was in the office for over 12 years. I prosecuted and tried over 200 cases to jury, including all kinds of serious cases, including gang-related homicides and involuntary manslaughter cases. What this case was about, it involved a 15-year-old troubled youth who took a firearm purchased for him by his father to his high school, where he shot and killed 4 of his classmates. His parents were charged with involuntary manslaughter, which the prosecution had to prove that his parents were grossly negligent in purchasing a firearm for him, but also, most importantly and most difficult for the prosecution, proving that it was foreseeable that their negligence would lead to the death of these 4 young people. So involuntary manslaughter, traditionally in common law, it was called depraved heart murder, which essentially is that you're showing such negligence that it's foreseeable that someone would die as a result of your conduct. So for example, a very easy example would be is if I set up a trap for the mailman who I know every day comes to my house and opens the mailbox and I put a bomb in there. It's foreseeable my gross negligence would kill him when he opened up the mailbox. I think the implication of this case going forward is multifaceted. It's a case of you better be careful of what you wish for. So I think this could have implication for the parents of children or minors who the parents know are engaged in dealing drugs, like for example with the fentanyl crisis that's going on. If you could show that a parent knew that their minor child was engaged in trafficking of drugs, narcotics, in particular fentanyl, and someone were to die as a result of that, there could be future prosecutions in those type of cases. I would think in more school shooting cases, you could see other jurisdictions and prosecutors in other jurisdictions to seek to use the Crumbley case and the theory behind it to try and get convictions in their own jurisdictions. Also, I think they'll feel pressure to do so. I think you could see it within the context of gang-related cases, specifically in situations where parents knew that their children were involved with gangs, which is very, very common, and did nothing to stop that. It's highly foreseeable that gangs involve violence, potential death. So there could be prosecutions and that kind of stuff. To be fair, this really opens up a Pandora's box of potential liability for parents going forward, depending on how far prosecutors seek to do this. I guess I would ask the question, is this just? I mean, I understand, people are very upset about these school shootings and they feel helpless and they feel like no one's doing anything about it, but is this just? Is this something, how far are we willing to take this? Traditionally, crimes require that I engage in a criminal act, I have the intent to do the criminal act. Is this a direction that we want to go?